Well, like Professor Milroy, I'm also going to draw on some connections between UK history and Canadian history regarding the charging and prosecution of women accused of maternal neonaticide. But my focus is on the invention of the charge of infanticide, first defined as a criminal offence in 1948 as an amendment to the Canadian Criminal Code. This is, of course, not to say that neonaticides were unknown or unpoliced or unpunished before that point. Prior to 1948, people, not necessarily females or mothers, suspected of culpable homicides of infants could be prosecuted for murder or manslaughter, as we've heard in some of the earlier presentations. In Canada, the mandatory penalty of death was the punishment for murder until capital punishment was abolished in 1976. The lesser offense of manslaughter carried a maximum penalty of life in prison at the discretion of the sentencing judge. Additionally, mothers alone could be charged with the concealment of birth or neglect. So women found guilty of concealment faced a maximum penalty of 2 years imprisonment, as we've heard for England as well. The other offense, neglect, concerned its consequences. If a mother's neglect was found to permanently injure her child or lead to its death, she could be convicted unless she could prove the injury or death was not caused by her neglect. So here again we have a reverse onus offense. Punishable up to life imprisonment if the child died, or up to 7 years if her motive was to, quote, conceal the fact of her having had a child, unquote. So that leaves us then with two generic culpable homicide offenses, every one who commits murder or manslaughter, plus two gender-specific offenses, every woman who, under which infanticide could be prosecuted before 1948. By comparison, the UK Parliament passed an infanticide statute in 1922 with minor revisions in 1938. So whenever two jurisdictions sharing legal foundations and case law pass similar legislation 26 years apart, the question of what accounts for a significant time gap arises. To answer this question, it's important to bear in mind that the Dominion was responsible for its own criminal legislation from Confederation in 1967, and Canadian legislators never simply aped the acts of their UK counterparts. For example, in 1908, Britain introduced a Court of Criminal Appeal, but Canada never followed. Similarly, British legislators removed the death penalty for rape in 1840, but Canada retained it until 1954. So perhaps the answer to our question is that Canada was less concerned about the rights of the accused and harsher toward homicidal or neglectful mothers, content to punish them for murder and manslaughter. According to the leading legal scholar of infanticide's regulation in Canada, that hypothesis is implausible for two reasons. First, trial records show that most women charged with murder or manslaughter pleaded guilty to concealment in the century leading up to the statute. Second, the politicians and legal commentators who advocated the legislation stated a lesser culpable homicide offense was necessary to counter jurors' reluctance to expose infanticidal women to harsh punishment. In particular, the Minister of Justice who introduced the bill in 1948 stated, "It is useless to lay a charge of murder against the woman because invariably juries will not bring in a verdict of guilty. They have sympathy with the mother because of the situation in which she has found herself." He also stressed that concealment of birth was an inappropriate substitute for murder or manslaughter, since the women charged were concealing deaths, not births. Yet the minister's concern was hardly novel. Complaints of a similar nature are evident from the late 19th century. So our question then becomes, why in 1948 did the government decide to act on long-standing concerns? Many scholars attribute the invention of infanticide to the psychiatrization of women's violence and the post-war jump in the authority of forensic psychiatry, creating new possible findings about postpartum depression and psychosis. This hypothesis fits with feminist and Foucauldian research that interrogates psychiatry's role in rendering women mad, not bad. The text of the statute certainly refers to mental disturbance specific to childbirth. It creates a new form of culpable homicide by a woman on her newly born child, if at the time of the act or omission she had not fully recovered from the effect of giving birth to such a child, and by reason thereof the balance of her mind was then disturbed. So on the face of it, this biopsychological terminology provided no scope for the situation new mothers faced in the lead up to neonaticides, the very factors lay jurors appeared to consider when they nullified evidence or expressed paternalistic concern. And I use that word purposely because only men could serve on criminal juries in Canada until the 1950s. Again, a difference from the UK. It's from the very late 1910s that women can serve on juries in England. Yet there is no evidence the government consulted psychiatrists before amending the law. Instead, two more plausible factors that have received little attention played a role in the lead up to Canada's infanticide law. The first is contextual. The post-war period saw a move to modernize the criminal code, which had not been substantially revised since 1893. By the 1940s, the Canadian Bar Association, CBA, which was the legal profession's peak body, formally advised the government on reformulating the criminal law. Prosecutions for infanticide constituted the second factor, particularly two high-profile cases that illustrated the need for legislative means to avert the problem of a lack of uniformity in the treatment of this crime and those accused of committing it. Significantly, psychiatric expertise played a negligible role in just one of those two trials, and in both cases, the accused woman was convicted. The first case, a 1940 trial for murder, demonstrates both typical and atypical features of maternal neonaticide prosecutions in the mid-20th century. The other, a 1947 trial, occurred just before the government passed the bill, and it was unique in the prosecution of culpable homicide. However, both women were tried at a time when the federal government responded to calls for greater uniformity in sentencing and punishment, and the outcomes of these two cases took on greater significance as a result. Annie Rublitz, a single 19-year-old of Ukrainian heritage, was just the sort of defendant most jurors approached sympathetically. The teenager lived on a farm with her sister and brother-in-law, and on the 8th of June 1940, she gave birth to a daughter who died within minutes of her birth, when Rublitz was alone and unaided. She did not tell her sister how the baby had died, but the two decided to bury the infant on the farm without reporting the death. They clothed the baby, they put in a cross, they put it in a special box, and they bury it. Events of this nature were undoubtedly repeated, unbeknownst to authorities, hundreds of times, but in this case, as we've seen in others discussed earlier, a suspicious and hostile relative informed the police. Rublitz might have faced a comparatively minor charge, failing to report a death or concealment, had she not confessed to police, who did not caution her, that she had placed her hand over the infant's mouth, fearing there was no one to look after it. Her admission led police to charge her with murder, and the Crown tried her for the offense, bolstered, as Milroy's presentation showed, by the pathologist's flotation test of the exhumed infant's lungs that indicated it was not stillborn. Well, a poor immigrant farmhand had no means to hire a barrister, but the profession ensured a defense was always provided to people charged with capital offenses. So Rublitz's pro bono barrister likely hoped that the mitigating evidence, the fact that she faced birth alone, also evidence that was disclosed to the police, that the brother-in-law was the father of the child, plus her young age, 19, she's referred to as a girl, would lead the jury to a clement decision. the sort that the Minister of Justice criticized. However, the trial judge refused the defense's request that he charge the jury on a possible verdict of manslaughter or concealment of birth. In fact, 2 hours into the jury's deliberations, the foreman asked if they could find her guilty of a lesser charge, but the judge says it's either murder, guilty, or not guilty, plus there was no evidence presented at trial that she was insane. Under the judge's rather restrictive instructions, the jury found Rublitz guilty of murder, but they added a strong recommendation, as they put it, in view of the circumstances surrounding the case. Well, as I've said, the mandatory sentence for murder was death, and the judge sentenced Rublitz to be executed, although he did agree with the jury that mercy be considered. Numerous individuals campaigned for clemency, and Rublitz's lawyer appealed the conviction successfully. Retried, she was convicted of concealment of birth, and her punishment shifted from the exceptionally harsh to the comparatively mild sentence of time served. However, the unexpected initial verdict generated an ongoing campaign to change Canada's law of homicide, to make the fate of defendants such as Rublitz less dependent on judges' charges, juries' feelings, and lawyers' chances at criminal appeals. Saskatchewan's Attorney General was the authority who first lobbied the Minister of Justice to consider a change in the Criminal Code in 1940. In addition, the chairman of the Saskatchewan branch of the CBA took up the cause, and he used Rublitz's conviction for murder to argue that Canada should amend the criminal law as England and Wales had done most recently in 1938. In 1940, the federal government was unreceptive, in part because existing practices worked in favor of most women accused of infanticide. And many criminal experts in this period considered mothers less culpable and the offense less serious than adult murders. For example, this second clipping from 1940, which we see on the right, came from another provincial attorney general, the Ontario Attorney General. In his opinion, revising the code was unnecessary since juries, quote, generally refused to bring in a verdict of guilty of murder in cases of newborn killings by their mothers. In other words, jury nullification, a product of chivalrous male jurors, meant justice was done through layperson's discretion, not legislation and not by experts. However, the shift toward a less discretionary, more formal solution began in 1946, the year the CBA began to advise the government on bringing greater uniformity to the criminal law. That was the same year the professional body recommended modifying the law of culpable homicide legislatively to incorporate infanticide as a non-capital offense. Again, this was inspired by modernizing legal reforms, not the lobbying efforts of psychiatrists. In Canadian infanticide trials in the mid-20th century, psychiatrists rarely appeared unless the defense of insanity was raised, or the judge suspected that the defendant was insane and ordered a psychiatric assessment. For criminal reformers, Rublitz's fate, the rare conviction of a woman for murder, despite jurors' reluctance to convict her on a capital charge, dramatized the law of homicide's inflexibility, which led to a lack of uniformity in the punishment of infanticide. Few were charged with murder, and most pled guilty to concealment. Many defendants prosecuted for murder faced jurors prepared to nullify. Most judges charged on concealment in trials for murder or manslaughter, and the majority ended up with light sentences, with some sent to moral reform institutions, and very occasionally, some were sentenced to death. The Rublitz case likely remained on some politicians' minds as the government introduced its infanticide bill midway through 1948. But a second scandalous trial of 1947 was undoubtedly top of mind, since it was uniquely scandalous. The defendant, Mrs. Evelyn Dick, was convicted of murdering her newborn son shortly after she had been tried twice for conspiring to murder her husband. The first trial ended in a finding of guilt. It was appealed. She was retried for murder. The second trial, she was acquitted. This case was exceptional in every respect. The glamorous, publicity-seeking 27-year-old lived in an industrial city on the outskirts of Toronto. Because the body of Mr. Dick was discovered dismembered, the case was dubbed the torso murder, and it garnered international headlines. The brilliant lawyer who defended her in her murder trials, saving her from the gallows twice, defended her yet again in her third murder trial in the spring of 1947 for the death of her infant son 3 years earlier. When the police searched her home for evidence connected to her husband's murder, they found a deceased baby boy encased in concrete inside a suitcase and wrapped in a skirt with Evelyn Dick's name on the waistband. During her trial, the prosecution disclosed this was the defendant's third illegitimate child she had before her marriage, whom she claimed she had given up for adoption before she left the hospital where she gave birth. In this trial of a mother charged with the murder of her infant, the jury found her guilty of manslaughter, giving the judge sentencing discretion. The defense had called a psychiatrist who testified the defendant had a low mentality, but the doctor admitted to the judge that she could tell right from wrong and understood the consequences of her actions. The judge made the unusual decision in this case that the woman serve the maximum penalty for manslaughter, life in prison. And the sentence appears to have reflected his low opinion of her. "You have committed a horrible crime," he said as he addressed the convicted prisoner. Many observers assumed the stiff sentence was imposed to compensate for the legal technicalities that had allowed Evelyn Dick to evade criminal responsibility for her part in her husband's death. Other conspirators were convicted. Evelyn Dick's lawyer certainly knew the sentence greatly exceeded the average sentence for manslaughter in that period, which was about 5 years. And this was the basis of his appeal against the sentence before the Ontario Court of Appeal. Not only did the court deny the appeal, but the Chief Justice was moved to add his own condemnation of the prisoner's failings as a woman and as a mother. He said, "While the appellant has no previous criminal record or earlier conviction, she has obviously chosen an evil mode of life. This child," the victim, "was her third illegitimate child." Evidently, the Chief Justice endorsed a sentence that punished her for her lax morals, not just for manslaughter. And he went further. Now, all he had to do was say the appeal is refused, but he feels moved to add these comments. "She has not the usual dislike of gruesome deeds that one would expect from a person in her years. The way in which she disposed the child was of a callous nature. And finally, Mrs. Dick showed a lack of maternal instinct." Although there was no evidence this prisoner had changed her stripes while awaiting trial, the Chief Justice suggested that she might be released from prison, but only once she showed, quote, "definite signs of having altered her personal character." So, about 8 months later, we get this bill. The reference to the unbalanced mind of the accused in the final statute of 1948 was merely an imprecise psychological gloss on the government's attempt to replace jurors' sympathies with a modified law. Interestingly, the low maximum penalty of 3 years, compared with England's statute of 1938, which still prescribed life imprisonment as the maximum for infanticide, evidently expressed the sentiments conveyed by Evelyn Dick's lawyer, that infanticide was a crime less grave than the murder of an adult, and the perpetrator less culpable. Yet Canada did not do away with the alternative charges of murder or manslaughter for homicides of infants, and Evelyn Dick's conviction underscored why this prosecutorial option remained in use. The invention of infanticide did not lead to the replacement of juror sympathy by a psychosocial understanding of maternal neonaticide after 1948. Indeed, the opposite has occurred in decades since Canada introduced its infanticide law, supported by the assumption that women now have multiple options from contraception to adoption. And in cases since the 1970s, the moral condemnation of accused women, akin to the castigation of Evelyn Dick, has typified prosecutions and press accounts of the accused. And this has occurred despite the still dubious method of the lung flotation test and most defendants' incapacity to enlist experts such as Christopher Milroy to counter it. Thank you.